Let's talk about ownership. Freehold, the word freehold, means ownership. So freehold rights or freehold estates are estates in ownership. If you have less than freehold, obviously it would be less than ownership. So the word freehold means ownership. When you come to real estate school, you understand that most people walk through the door and they feel like there's only one kind of ownership. But then you learn that there's other kinds of ownership other than the one you thought that there was. For example, fee simple is the most comprehensive ownership that a person can have, also called fee simple absolute, ownership in fee. This is the most comprehensive kind of ownership that an individual can get. There are two distinguishing characteristics. The first is that it lasts for an indefinite duration. In other words, there's no strings attached. No one can come take it away from you for doing something or for not doing something. So fee simple absolute, or just fee, lasts for an indefinite duration. The second distinguishing characteristic is that fee is freely inheritable. It's freely inheritable. If an ownership will pass those two tests, then you know it's fee. If it can't pass those two tests, then you know it's some sort of weird science ownership, not the one you're mostly familiar with, the one that we as real estate agents sell, list, and receive commissions for. The other types of ownerships are ownerships with strings attached. They're either qualified or defeasible, also called determinable. So fee simple determinable, fee simple qualified, or fee simple defeasible are ownerships with strings attached. There's something that could happen in the future where the grantor could pull this ownership back. One of the primary ones you need to be familiar with is a life estate. Is a life estate ownership? Oh yeah, sure. All these different types are ownership, but they're just weird science ownership. In a life estate, what happens is a grantor sets up an estate that will give a person ownership, but only for somebody else's life. Normally, these are set up with the holder of the life estate being the calendar or the actual life. So, a grantor may give a life estate to a daughter or a former spouse or anyone that they can live there and use that property as though it was theirs for their lifetime. But sometimes life estates are set up with a different person being the calendar or the clock on the life estate. And that person, if they set it up that way, it's called pure atre vie, or based on the life of another. Life estates can be set up so that when this life is extinguished, the estate, of course, ends, and then it either goes back to the grantor, which is called estate in reversion, or it goes to somebody else, which is called estate in remainder. That person who gets the property as estate in remainder is also called remainder man, and they get an official cape and t-shirt to go with their eventual ownership of the life estate. Moving on to another category now, we want to talk about joint tenancy. This is still under ownership, but joint tenancy is a type of ownership that has within it the full rights of survivorship. And what that means is the last man standing gets the property. If there were 4 owners and then 3 of them died, the 4th one ends up owning the entire property. So the surviving owners' right of survivorship end up with ownership. In order to accomplish joint tenancy, you have to have 4 unities. The 4 unities can be remembered with the mnemonic device PITT, P-I-T-T, possession, interest, time, and title. If you break one of these unities, or if you try to set up joint tenancy and violate one of these unities, you don't have joint tenancy. For example, possession. Every owner must have an equal right to the possession of the property. Interest, every owner must have the same percentage of ownership. If there's 3 owners, they each own 1/3. 2 owners, they each own half. One of the things that helps you determine whether something is not joint tenancy is when there is a division of ownership where one person owns more than another. That violates the unity of interest and therefore could not be joint tenancy. Time, all owners came into the ownership of the property at the same time. And title, they were all put in ownership with the same document. You have to have these 4 unities in order to have joint tenancy. Now let's talk about some specific wake-up items in regards to joint tenancy. If A, B, and C owned a property together as joint tenants, and then B died, and then C sells his half interest to Z, Then we have two new owners, A and Z. And what is their relationship? Well, it would have to be tenants in common. Because when A, B, and C owned it together, and then B died, A and C were 50-50 owners. And then C sold his property to Z. Z came into ownership at a different time with a different document than A. And so those two remaining owners, A and Z, would have to be tenants in common. As a husband and wife, if you own a property as joint tenants, can one spouse sell the property without talking to or getting permission of the other spouse? And the answer is yes, they can. Now, obviously, it won't do much for the marriage, but still, it can happen. So you come home one day, and instead of your spouse being there, there's a new owner of the property. And obviously, they only own 50% because that's all the spouse could sell them. However, you and this new owner would be what? That's right, tenants in common, because they came into title at a different time with a different document. What about an individual that owns a property alone? They own it in severalty. And then this person becomes married and desires his new spouse to be a joint tenant with full rights of survivorship. So he decides to do this. Could he transfer one half of the ownership of his property previously held in severalty to the new spouse and on a deed say it shall be vested as a joint tenant with full rights of survivorship? No, that won't work because he or she came into ownership at a different time with a different document. In order to accomplish going from ownership in severalty to ownership as a joint tenant with full rights of survivorship, you would have to do that with the former person owning it in severalty giving the property to both of us. So A, for example, would have to transfer to A and W, and so that A and W came into title at the same time with the same document. That would accomplish joint tenancy. Another example might be if you were a spouse, let's say it's a husband and wife, and they have 3 children, and then the husband, who happens to be an insurance agent, dies, leaving a very good death benefit for the wife in the orphan children. The wife subsequently marries again, so there's husband number 2. The wife and husband number 2 decide to buy a property together. Husband number 2 is anteing up his half from his own estate, and the wife is anteing up her half from the estate that was pretty much set up and accomplished by the death benefit of her former husband's life insurance policy. So in accordance with her feeling, she tells her new husband that should she die, she wants her 3 children to inherit her half interest in the property. Her new spouse is okay with this, but they're vested in title as joint tenants with full rights of survivorship. If that happened, and then she died later, she may have a will that says that her half interests go to her children, but the will won't do any good. The property, because of joint tenancy with full rights of survivorship, will go to the new spouse, regardless of what the will says, because there's an instant between death and after death. At death, joint tenancy kicks in. After death, well, that's when the will would kick in, but she doesn't own the property then. What about 3 owners that own a property as joint tenants, A, B, and C? And then C sells a 1/3 interest to Z. What is Z's relationship to A and B? Well, obviously, Z would have to be a tenant in common because he came into title at a different time with a different document. But more importantly, what is A and B's relationship? Well, their relationship has not changed. So the 2/3 owned by A and B are still held as joint tenancy with full rights of survivorship. Z, since he came in later, would be a tenant in common. But if A died or B died, the surviving partner would inherit the full interest in the 2/3 share. Tenants in common is a type of ownership where you only need one unity. Tenants in common is the only way that a corporation can own a property with someone else. Community property issues come up only in community property states. The community property states are few. They're only California, Idaho, Arizona, Texas, New Mexico, Louisiana, Wisconsin, or Nevada. All these states either have French or Spanish traditions. Wisconsin voted it in, but it still had French traditions anyway. States such as Colorado or Utah and all the other states in the United States, other than those that I mentioned, use Old English common law and not Spanish traditions. In a community property state, the big issue is what is separate and what is ours. In most states, you can look at the vesting of title and it tells you who owns the property. But in a community property state, even though one spouse is the only person vested in title, it may be owned by both spouses. A partition action is a situation where partners can't agree, so they sue each other in order to split the property up. I guess the ultimate partition action would be a divorce. In a limited partnership, it's a type of entity where there are general and limited partners. You have to have at least one general, but a limited partner has limited liability. Someone who invests in a syndication and takes on limited liability might be called a limited partner. If you do work with corporations that are buying and selling property, that's not a problem. You're licensed for that. But can you sell stock in a corporation? And of course the answer is no. A real estate license doesn't give you the opportunity to sell stock or securities or insurance. It only gives you the right to sell real estate. If you get into a situation where there's a hassle or a squabble over a title, and a person claims ownership, or perhaps it's at the end of the 7-year adverse possession claim, you settle all this by going to court, and the suit is called a quiet title action. For instance, if K bought a property that they believed they were buying in fee, that they were getting fee simple absolute, but 40 years later they find out that they did not get fee simple absolute, they only received a life estate. They bought a life estate from the individual that had owned the property. They didn't buy fee simple ownership. But no remainder man or no grantor can be found that would come in for estate in reversion rights. So after 40 years they've discovered all this, well, they could just file a quiet title action and claim adverse possession.